My name is Richard Rosario.
Barry Gibbs.
Peter Pringle.
Keith Howard.
Sonny Jacobs.
And I spent 34 years.
19 years.
17 years.
15 years.
20 years in prison.
For a crime I didn't commit.
For a crime I didn't commit.
For a crime I did not commit.
For a crime I didn't commit.
For a crime that I did not commit.
Wrongful convictions have gained increasing attention since the release of DNA evidence. However, compensations for wrongfully convicted individuals is a topic largely operating outside of public discourse. In 2004, Congress passed the Justice for All Act, which compensates individuals who were wrongfully convicted of federal crimes, giving them $50,000 for every year spent in prison and $100,000 for every year spent on death row. 19 states have no laws providing compensation for the wrongfully convicted. 31 states and the District of Columbia have statutes providing varying forms and levels of compensation, with payment schemes that fall into three general categories. 3 states index the compensation to a median or per capita income, ranging from $30,000 a year to $142,000 each year. 14 states follow the federal government model, compensating individuals for every year or every day they were wrongfully incarcerated. The yearly compensation ranges from $25,000 to $80,000. Iowa and Missouri compensate individuals $50 for every day spent in prison, for a total of $18,250 each year. 14 states and Washington, D.C. allow for varying levels of discretion when providing compensation. D.C., Maryland, New York, and West Virginia have broad discretion, with no specified maximum or minimum award. Alabama and Minnesota require a minimum of $50,000 for each year wrongfully incarcerated, and 9 states set maximum awards ranging from $20,000 to $500,000 per claim. In Florida, wrongfully incarcerated individuals are ineligible for compensation if they have committed a violent felony or more than one nonviolent felony prior to or during the wrongful conviction. By denying compensation due to criminal activity entirely unrelated to the wrongful conviction, the state of Florida is essentially pointing to the individual's disposition as the reason for their wrongful conviction. The state sees wrongfully convicted individuals with prior felonies convictions as stick, as deserving of their situation, while those without prior convictions are ball, deserving of compensation for their wrongful incarceration.
Racial and class factors notwithstanding, when it comes to issues involving incarceration, society tends to classify itself into 2 groups. The first group consists of law-abiding, hardworking citizens, in essence, assets to society. The second group consists of criminals and miscreants, essentially social liabilities. Presumably, the first group dominates the second group numerically and in other ways. When an individual deemed to be in the second group is convicted and incarcerated rightfully or wrongfully, the predominant instinct of the member of the first group is to engage in out-group derogation, that is, to perceive members of the second group as threatening the members of the first group and thus more deserving of their fates. This is further exacerbated when the person convicted was convicted in error. The prior classification of the wrongfully convicted person as a member of the outgroup diminishes the sympathy they might otherwise have elicited towards this person, resulting in compensation exemption statutes as we see in Florida. In-groups tend to look at members of outgroups as dispositionist actors, and thus assign some form of dispositionist blame to wrongfully convicted persons. Moreover, system justification theory argues that there is a fundamental human motivation to justify the status quo. People tend to justify the criminal justice system we currently have, leading to the belief that our system could not have convicted truly innocent people. Therefore, even when wrongfully convicted or deemed factually innocent, defenders of the criminal justice system believe they must have done something to end up in prison. Thus, they are motivated to defend the system by attributing bad characteristics to the wrongfully convicted people. This in turn reduces the dissonance they feel arising out of the discrepancy between reality and one's beliefs about the system. We can measure these in-group dispositionist attributions on wrongfully convicted persons by examining other systems of compensation. In tort cases involving false arrest, illegal detainment, and involuntary medication, compensation greatly exceeds that received by wrongfully convicted people in the same states. Here are a few examples. In Mississippi, a plaintiff who was sexually abused repeatedly for a year while in custody of the Mississippi Department of Human Services received $500,000 for their injuries. By contrast, an inmate who was wrongfully imprisoned for a year in Mississippi receives $50,000 per year. In Massachusetts, a Massachusetts court awarded $315,000 in compensatory and punitive damages for the false arrest and detention of a disabled individual in a state hospital. However, for wrongfully convicted inmates, the daily maximum compensation is $137. In California, a court awarded a plaintiff $52,000 for 6 days of illegal detention and involuntary medication of a psychiatric patient by the university hospital and physicians. On the other hand, individuals wrongfully convicted for 6 days in California would receive only $840. These results demonstrate how little wrongfully convicted people are compensated compared to tort cases where the plaintiff suffered similar psychological and emotional circumstances due to wrongful procedures. Despite current disparities in compensation, these statutes also fail to account for the unique circumstances of the wrongfully convicted. Wrongfully convicted individuals are randomly trapped in cages and exposed to daily injustices and deprivations, continuous and at random, all without any ability to escape. They committed no crimes. Their experience injustice is without reason. If on death row, they live with the psychological fear of their impending death, obsessing with execution dates and their state-sanctioned killing. When released, many wrongfully convicted persons express that they feel as if they are still in prison. They can't relate to people in society because no one understands what they've gone through. Somewhere in their minds, they're still in prison. That is learned helplessness. In Seligman and Maurer's 1967 experiment, they showed how random, uncontrollable, and continuous shocks to dogs can create a feeling of inescapability known as learned helplessness. Dogs in the experiment could exert no control over their circumstance, even when eventually given the opportunity to change their situation. They did nothing and continued to experience the pain of the shocks. In the poverty context, individuals who grow up in poverty experience a particular type of stress that is inescapable and has been described as learned helplessness by psychologists. The difference between poverty and other stress is often our own stress is escapable. In the context of wrongfully convicted individuals, many of whom are poor, they exhibit psychological harms. They live shorter lives, they have more psychological and health issues, and even exhibit physiological changes associated with learned helplessness in poverty, such as the shrinking of the amygdala and hippocampus. State compensation statutes don't consider these individualized emotional and psychological harms. Should we have a more individualized compensation system in the wrongful convictions context?
I have been free for almost 2 years, and I still cry at night because no one out here can relate to what I've gone through. I battle with these feelings of loneliness. I've tried therapy, but it didn't work. The therapist was crying more than me.